That's right. All right, sir. Are you Darren Tamble?
Yes, ma'am.
And Ms. Holmes, will your client waive the formal reading of the indictment?
Yes, Your Honor. Now we're going on count one. I don't think, is there multiple counts on the
There are.
It's
Just
count
count
one.
Okay, let me get that. Okay, getting there. Mr. Tamble, in cause number 25 DCCR 1802, the state has elected to proceed on count one only. It alleges you committed the third-degree felony offense of assault on hospital personnel on hospital property October 15th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes? Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Tamble is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a hospital personnel in count 1, a third-degree felony. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. All right. Thank you, sir. You can go back with bailiff. Thank you, Ms. Holmes.
Okay.
All right, Angela Reyes. What? Oh. Good morning, ma'am. Were you Angela Reyes?
Yes, ma'am.
And Ms. Reyes is charged in cause number 26 DCCR 0264 with assault on a peace officer, 26 DCCR 0265 with the obstruction or retaliation, and 26 DCCR 0266 with assault on a peace officer. Those offense dates are all from December 22nd of 2025. It looks like the cases were indicted February 11th of 2026. And so, Ms. Reyes, let me just get everything straight first. Were you released on accusation when you first got arrested on these offenses?
Yes, ma'am.
And then the indictments came down and there were warrants and you went back into custody,
Yes,
correct? Do you, Mike can tell, but do you remember the date that you went back into custody?
I know it was Wednesday last week when they picked me up on a warrant from my
Okay.
house.
So was it? Okay. The 25th, February 25th.
Yes, ma'am.
This shows when these were executed. You were magistrated out at the jail that next morning, and it appears as though the magistrate set the bonds at $10,000 for the 2 assault on a peace officer charges and $8,000 on the obstruction charge. The district attorney's office has filed an Article 17 objection to that bond, asking that I increase the bond. Have you been arrested for anything? Well, let me do this first. Raise your right hand the best you can. You swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay. So from the date of these offenses in December 22nd of 2025, have you been arrested for anything else?
Since December?
Yes,
No,
ma'am.
I have not.
Okay.
And this is my first big I've ever.
These are your first felonies?
Yes.
And Mr. Coleman, you're shaking your head. Do you agree that there's nothing in your file that shows that there's any felony criminal history?
I agree.
Okay. Let me do this real quick because typically this review is going to be it's a new type of a law that has been handed down for the district attorney's office and the courts to review certain bonds that the magistrate set. But typically that is going to be when you're on bond for one felony and then another felony is alleged to have been committed, which we don't have here. And so let me take a quick look at the probable cause in these cases, and then I'll let you guys kind of know where I stand on it. And Ms. Reyes, have you ever had any type of mental health assessments or counseling, or are there any issues that you have going on that you feel like you would need that?
I will say a year ago in February, I survived a suicide attempt, but I had to get hospitalized. And that's where they did evaluations and diagnosed me with depression. So I've been off my medicine because my insurance lapsed because I just had a baby in September. And I haven't been able to take it since I started getting back on it whenever I went into custody. So they set me up on that.
If you make your bond as it's set now, or depending on what it is, where would you reside?
With my father and my 2 children at the 7515 North Major.
Okay. Well, that's where you were when they came to get you and arguing with your dad. Is that correct?
It was with my fiance. It was virtual.
Okay. You were arguing with your fiance, or your fiance was arguing with your dad, or who was arguing with who?
It was me and my fiance, and then my dad was the one who called the police.
Okay. Where would your fiance be living?
He lives there too. Also.
Okay, so here's where, at least while this is pending, there could be some issues. Well, Mr. Coleman, I guess based on where I've gone kind of so far with this, what is your position with regard to the motion that your office filed?
We'd simply just ask that the court give the motion its due consideration, and certainly we defer to the discretion of the court.
Mr. Lewis?
Judge, well, I had conversations with Ms. Reyes' father, who was there, and the one who called the police. And as far as a bond goes, my conversation with him was that even the amount that is set could be a stretch for them to try to make. And also, like I said, with some of the issues that she was already having, part of that was her not being able to have her medication because it was a financial issue. So, of course, we'll be asking if the bond remains as the same. But like I said, if they are able to make that bond, that would definitely be an amount that, would definitely ensure her return to court and, any public safety issues.
All right, then here's what I'm going to do. At this time, I'm not going to raise your bonds in your cases. I'm going to deny the state's motion to raise those bonds. I am going to make a condition of the bonds, if you make them, that you make appointment and go to the Spindletop Center for treatment, medication, assessment. They will work with you without insurance. And so it's going to be a condition of your bond that you do that. So you need to make sure if you make your bond that when you make that appointment, you get that appointment to Mr. Lewis and your bondsman so they know you're following through. So I know you're following through. And that's really just meant, if for me to order, it means that they should be able to help you more
Yeah.
because it's a court order.
Mhm.
And so there's no reason for you not to go do that. And
Yeah.
now if you don't do it, it'd be a violation of your bond. And obviously at that point, Mr. Coleman might have more to say than he did today. And we would have some concern about some of the same behavior, and I would have no choice but to raise those bonds. Do you understand?
Yes, ma'am.
Okay. All right. You can go back with the bailiff.
All right, thanks.
Thank you.
Thanks, Jeff.
For the new case.
There it is. Sorry. Nope. All good. All right, ma'am. Are you Lee Coney?
Yes, ma'am.
And so we've got two cases here. We've got 25 DCCR 1274, which is a new offense. And then there is 24 DCCR 1600, which is an MTRP. We were previously here in the motion to revoke case. And we were set for a hearing this afternoon. And Miss Coney, was previously here. It entered pleas of true to count 3, 4, 6, and 7. Got an updated pre-sentence report. First of all, have you both had an opportunity to review that report?
Yes, Your Honor.
Yes, we have.
Okay, any additions or corrections to that?
No, Your Honor.
Not for the sentence.
And so what I'll do is let's go through the new case since there's an agreement, and then I'll go through the sentencing and that MTRP so that I know exactly what's going on. And will she waive the formal reading of the indictment in the new case?
So moved.
Ms. Coney, in cause number 25, DCCR 1274, you're charged with the state jail felony offense of possession of a controlled substance from September 12th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them? And do you understand, if I follow this agreement, that you will be waiving or giving up any right to appeal?
Yes.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes.
And it looks like the agreement that you've reached is for a 20-month term in the state jail prison. And the state would run concurrently with that motion to revoke case in cause number 24, DCCR 1600. Also, the state has agreed not to file cases that have been, I guess, received but not filed yet on an offense date of November 1st of 2025. Is that
They have
correct?
not yet been received, Your Honor. The
Okay.
labs are pending.
Okay, same types of offenses.
Yes.
Your own offenses.
Yeah.
All right. Is that your understanding of the agreement?
If-
State tenders number 1.
Without objection.
It's admitted. Is there any evidence that Ms. Coney is not competent?
Not that I'm aware of, Your Honor.
All right, ma'am. In cause number 25, DCCR 1274, I find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with that agreement to a term of 20 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And so then there was no agreement in cause number 24, DCCR 1600. Is it the, I guess, recommendation at this time that I sentence her in accordance with what that plea was?
Yes, Your Honor.
So the 20 months would
20
be
months
so
concurrent with 1274 and refuse the 2, which I anticipate to be state jail and Class A.
okay. All right, then, based on that, then Ms. Coney, in cause number 24, DCCR 1600. Well, let me ask you, initially this was unagreed, and so there was a right to appeal, but it sounds like there's now an agreement, and some things that the state has done and given, I guess, in exchange for that. And so is it your understanding, and do you want me to follow that agreement now for a 20-month term in that motion to revoke it?
That's correct, Your Honor. She waives appeal.
So I am going to have you sign a document that shows that this is now a plea bargain, and so you've waived your right to appeal, and then I'll go forward.
So. Let's see. Yep.
All right, so then I'm going to find that you entered your pleas of true to counts 3, 4, 6, and 7 freely and voluntarily. Find those counts true, and at this time find sufficient evidence to find you guilty and find you guilty of theft of property. Sentence you in accordance with this new agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run together consecutively at the same time. The state agrees in both of those, not concurrently, concurrently. So they will run at the same time. And the state will agree to refuse the two cases from November 11th of 2025. I'm handing you in each of your cases the trial court certifications that shows that these were agreements that I followed. And so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, thank you. Good luck to you, ma'am. Thank you, Mr. Kimler. Thank you, Ms. French, for y'all discussing that and working it out.